So I want to talk to you today about PCPs. As you all, I think, will know, PCPs and the concept of a PCP is a regular bugbear of tribunals and certainly of the higher courts. In terms of what I want to go through today, first of all, I want to look at why we need a PCP for certain cases and what exactly they are. And then beyond that, I want to take you through what I regard as some common problems with provision criterions and practices, and ones that have caused problems in cases that have reached appellate level, and ones that regularly cause problem in my practice, and I'm sure the practice of all of those who practice in employment litigation in the room. So from the start, and apologies for those of you here who will feel that I'm teaching you to suck eggs, but we need to start at the start and we'll go from there. We need a PCP for certain claims. Without a provision criterion or practice, it's simply not possible to have an indirect discrimination claim. It's not possible to have a reasonable adjustment claim. And of course, indirect discrimination claims will apply right the way across the board to all protected characteristics. But we know that reasonable adjustment claims, we're looking at disability only. Within the handout that you have, you've got the relevant sections of the Equality Act, section 19 and sections 20 through 21. And a key concept, which you can see from those sections alone, but which continues to be problematic, is when you're identifying your provision criterion or practice, it must be that which places the particular group of which the claimant forms part at the particular or substantial disadvantage, depending upon the terminology that you're using. Very often that's lost. And what started from is, I am a claimant or potential claimant, and I am unhappy about this, therefore that is what places me at a particular disadvantage, and I am the one placed at the particular disadvantage. The starting point needs to be, what is the PCP? And that's made very clear to us through cases such as Environment Agency and Rowan, a case that has stood the test of time and continues to be reiterated by employment judges across the land. You cannot get to the place where you have any valid reasonable adjustment claim, indirect discrimination claim, without identifying a valid provision, criterion, or practice first. Too often, reasonable adjustment claims start at, I think this was the failure. I think what happened here was a failure to make a reasonable adjustment. I still do appeals, and had a case relatively recently succeed on appeal, where the employment judge had probably given about 50 pages of findings of fact, really detailed and careful findings of fact. And there were approximately 3 paragraphs on the reasonable adjustment claim, in none of which was it apparent what the PCP was. It was very clear the employment judge was extremely unhappy with my client. That came across clearly. But what was also clear was that the tribunal, judge included, had jumped right the way through to the idea that there must have been, in these awful circumstances, a failure to make reasonable adjustments, without properly addressing the statutory test. So for reasonable adjustments, read Environment Agency and Rowan. For indirect discrimination, exactly the same principle applies. The starting point, and I would say where representing claimants, the starting point, even at pleading stage, is identifying something that is a valid PCP. Relatively recently, we had a very important case in the Court of Appeal, and the judgment of the former president of the Employment Appeal Tribunal, at that time Mrs. Justice Simler, now Lady Justice Simler. I've included in the handout some quotes from her judgment. There is no doubt, in my mind at least, that her judgment should mean that there is yet again a refocusing on PCPs for these sorts of claims, and also perhaps a moving away from the idea that these kinds of claims should just be thrown into the pot and considered when actually, if you really look at the facts, they're not justified. So looking at some of the quotes that you have, the things that I want to draw out are, first of all, that the idea that the words are broad and overlapping. There's case law that tells us that if you get into a scenario where you're trying to decide whether the particular PCP is a provision or a criterion or a practice, you're heading down a rabbit hole that won't lead you anywhere productive. It's just a term of art. They're not to be narrowly construed or unjustifiably limited. But importantly, what Lady Justice Simler said is that it's significant that Parliament, and jumping through the quote you have in the handout, did not use the words act or decision in addition or instead to the words PCP. And so what she said was that she found it difficult to see what the word practice could add to the words provision and criterion if all one-off decisions and acts necessarily qualify as PCPs. She said if something is simply done once without more, it's difficult to see on what basis it can be said to be done in practice. It's just done, and the words in practice add nothing. She explains then what PCPs are for and why they're there in the concept of indirect discrimination and reasonable adjustments. She explains that a PCP is there to identify what it is about the employer's management of the employee or its operation that causes substantial disadvantage or particular disadvantage, depending upon the section. And going back to this concept that you need to look at the actual PCP, not the individual, she says in both cases, those of indirect claims and reasonable adjustment claims, it's specifically the act of discrimination that must be justified isn't the disadvantage suffered by the claimant, but the specific PCP under, by, or in consequence of which the disadvantage is suffered. It must be capable of being applied to others because the comparison of disadvantage has to be made by reference to another comparator to which that same PCP could be applied. And she went on to say, and something which I have found useful both when pleading a case where I need to plead a PCP or where analysing a case where I'm for the employer in the case, that perhaps one of the best ways to look at establishing PCPs was to try and identify a state of affairs. And the concept of a state of affairs is there because that indicates how similar cases either have been, and of course, ideally you'll be able to say this PCP has been applied to this group of workers, but a state of affairs could also be something which would be applied in the future. And so whilst one-off acts or decisions are unlikely to be enough, if through those acts or decisions you can see that there is a state of affairs at the employer which would be repeated if similar circumstances arose, that is where you can potentially get a PCP type case where it could be, at least initially on its face, a one-off act or decision. Moving on to problems with PCPs, the starting point and the most obvious problem that we have with PCPs are poorly defined ones. Because of the drive in employment tribunals in recent years to try and case manage long before you get into the tribunal for the final hearing, this happens less in practice. But I still attend on cases where only at the trial is the PCP finally identified, and there's been some back and forth right the way through. Now, the reality of that, of course, is if that's what's been taking place, you can't marshal your evidence properly, either to establish the PCP or to demonstrate it doesn't take place. if someone is saying there is something like a state of affairs, but it's very vague what that is, how on the one hand, representing that employee, can you gather the correct evidence, focus the employee on providing the correct evidence to establish that that state of affairs would exist? And equally, if you're for the employer in that case, how, if it's vague, can you understand exactly what it is that you need to disprove? So it is essential that PCPs are identified at an early stage. Within the last year, I did a case that had reached final hearing where these were PCPs as far as the case management of that case had been carried out. A requirement to work in reception during the phased return, carrying out administrative duties. Well, on its face, that appears to apply to an individual in a particular circumstance, not something that you could easily say looks like something that's a state of affairs that might apply across the board. Refusing to provide a stool. How can that be a PCP? How can that be a provision, criterion, or practice that works across a workplace or a group? Giving the claimant the opportunity to stretch. Those are PCPs that have been identified through case management for a case for hearing. And it does no one any service to get to a hearing in that situation, because conceivably, the reality is the refusal to provide a stool was harassment. Someone knew about this person's disability, and the reality was they were just trying to make life difficult for them to create an offensive work environment. But what that meant was that the hearing itself didn't address really the test properly, and it made it extremely difficult for the claimant in that case to satisfy her PCP reasonable adjustment claim. And probably we were looking at the wrong claims, the wrong provisions in any case. Now, moving forward, one-offs is something which in Ishola, Lady Justice Simler specifically said cannot be a PCP. So if we slip back a slide, how many of those are realistically one-offs, one-off acts, one-off decisions? Probably all of them. The Court of Appeal has said those are not valid PCPs. That case probably shouldn't have been there as a PCP case when we got to the hearing. So that's one-offs, but there is an equally important passage in Ishola which I think illustrates a problem that still exists today. You have quoted in the handout a passage that starts, "In my judgment, however widely and purposively the concept of a PCP is to be interpreted, it does not apply to every act of unfair treatment of a particular employee." That passage goes on, missing a sentence, and says, "If an employer unfairly treats an employee by an act or decision, and neither direct discrimination nor disability-related discrimination is made out, because the act or decision was not done or made by reason of disability or other relevant ground, it is artificial and wrong to seek to convert them by a process of abstraction into the application of a discriminatory PCP." And that regularly happens. You regularly see cases where a set of facts has been contorted to try and get to a position where a PCP type claim could be run. Number one, that shouldn't happen. Number two, what Lady Justice Simler said in Ishola should provide for those who face these kinds of claims some ammunition for saying to a tribunal, this is not helpful. And one of the really good reasons for that is that by the time that you get to giving evidence, you often get a situation where the individual employee has absolutely no idea how their set of facts fit a PCP type case when that artificial process has taken place. So a recent example in my practice was a case where claims had already been struck out, and granted this was a litigant in person, and so it was difficult for them to navigate the Equality Act, as we all know it is. But this claimant had brought claims that are what you would call the scattergun approach of claims. Everything was in there. And claims for harassment, direct discrimination and equal pay had been struck out by the time that we reached the final hearing. But the claims for reasonable adjustments and indirect discrimination had continued despite not being on the face of the claim form. They'd been identified by the employment judge through a process of case management. The reality of the case was, when the claimant then had to try and advance those claims, he was simply unable to do so. He couldn't understand the concept, and it wasn't really what he believed. Towards the end of the hearing, in a situation where the case was all about COVID and someone trying to work from home, but being unable to do so because they couldn't get their computer provision to work with the employer's intranet, it came out that the reality was that as far as this employee was concerned, this was all harassment. And the employer had been deliberately preventing their internet access from working in order to expose them to risk of having to work outside the house. That's not an indirect discrimination or reasonable adjustment claim. When the claimant first put that claim before the tribunal, they hadn't described it as a reasonable adjustment or indirect discrimination claim. And yet that artificial process, in fact, had occurred through a process of case management, where you will often see a judge saying to a claimant, "Is this what you mean?" And when you have a litigant in person claimant and a judge saying, "Is this what you mean?" we all know what the answer is highly likely to be. That's not necessarily helpful to either the litigant in person or the tribunal. The next problem area of PCPs that I want to flag is reverse engineering PCPs. And going back to those examples of ill-defined PCPs, refusal to provide a stool is a good example of reverse engineered PCP. I wasn't given a stool. The PCP, therefore, is a refusal to provide one. So Ahmed was a case in which the wording of the PCPs relied upon changed right the way through it. So they changed at identification of PCPs in the pleading, at case management, and at the time of the hearing. And in fact, arguably in the judgment itself. That's obviously the problematic area that you don't want to be in, because how do you know that you're addressing the case that the judge is actually thinking about in the tribunal? But in that case, there had been a letter in which an adjustment to the number of days which would trigger an absent management policy had been set out. And the case focused on that letter rather than on identifying a PCP. And the reality was the PCP was the application of the absence management policy and the requirement to achieve a certain level of attendance prior to that being triggered. That was the PCP. It applied across the workforce. But they got sidetracked down the line of what this letter meant and whether it was reasonable or not to have increased from 8 days to something more than that. Examples of reverse engineering, the stool example, or the realistically, I was treated badly. I feel like I was treated badly. And the PCP often becomes whatever that bad treatment is. That's what the employer applies. There also in that case, from Judge Beard, was another definition of what a PCP is, which you'll see walks hand in hand with the concept of a state of affairs, where the employer has an expectation of the employee, and either the same expectation is made of other employees, or there's an element of repetition in the expectation with the particular employee. A state of affairs, a state of expectations across the workforce. That's what we're looking for. The next case is a case that is slightly different in that what we're looking at here is once you've got a valid PCP, particularly for an indirect discrimination claim, you need to be identifying a pool that actually matches the PCP that you've identified. So in Allen and Primark stores, the PCP was the requirement to be available for a Thursday late shift. And the indirect discrimination was to do with childcare requirements. The pool that was adopted by the employment tribunal was one which included 2 men who may have been willing to work on a Thursday evening when asked. And as a result of that, adverse impact wasn't made out because there were 2 men included in the pool balancing out the women in the pool. When that went up to the EAT, it was say, well, hold on, the PCP is a requirement, not would you mind doing something. It's when someone is compelled to work on a Thursday afternoon. And so the wrong pool had been identified and the matter was remitted, almost certainly with the effect that whether or not adverse impact was established would be reversed, because those 2 men would be omitted, and immediately you're looking at a different type of case. So in the next area, if you like, that there needs to be real care when looking at PCPs is ensuring that when you're then testing that PCP against a pool, the pool properly reflects what it is that you've identified as your valid PCP. And my last note of caution is treating policies as PCPs. In Martin and the City and County of Swansea, what happened was there was a discussion about the merits of a policy. And so the attendance management policy was discussed, and within it there were various dispensations to allow for accommodations for people who may suffer disabilities. And so the tribunal went down that road and established, well, there's no real substantial disadvantage when we analyse the policy, because look at all of the dispensations. But what the court said was that again is looking in the wrong way at a PCP, because the real PCP is the application of the policy at all. If you're someone who is disabled and because of that is more likely to be off sick, is it more or less likely that the policy is going to be applied to you, bearing in mind the trigger points? It doesn't matter what's in the policy, that potentially gets into play when you get it reasonable, whether an adjustment might be reasonable given what's in the policy. So again, the tribunal had gone off down the wrong route, and what they needed to focus on was a valid PCP, the PCP being, at a certain point, this policy will be applied to you. Does that cause substantial disadvantage to someone who's likely to be off more and therefore trigger the policy? Yes. Get past that, then look into what adjustments might be needed. And last of all, I want to finish on a note of caution from the judgment of the EAT in that case. The appeal, in fact, wasn't successful in that case because the reasonable adjustments had been analysed correctly. But the EAT judgment in the case includes even lawyers can falter when identifying the correct PCP. A practical and realistic approach should be adopted at the case management stage to identify a workable PCP, and should not thereafter be over fastidiously interpreted, with the result that a properly arguable claim can't be advanced. And then said, where a party is represented, the employment tribunal can expect the PCP to be properly identified, and so representatives should always consider how the PCP is pleaded with great care. And so if there is a takeaway from my talk today, then I hope that is wherever you're dealing with an indirect discrimination or reasonable adjustment case, have the PCP in mind even before the pleadings are done. Have the PCP in mind when you're looking at the conference, when you're deciding whether there's merit in those types of claims, and then try and identify that clearly and stick to it throughout the whole of the claim.